Hi there, I'm Krista Luther, and boy, today's probably your luckiest day. We're going to be covering purchase agreements. Pretty exciting stuff. I'm going to try to keep it to around 30 minutes. I would recommend that you have a purchase agreement in front of you. You can obviously take notes, but it might be easiest to underline something that you don't fully understand and maybe talk to your mentor about it later, or someone else, maybe a broker. The first thing that I'd like to point out on the purchase agreement is the tiniest writing right in the center right there. It says, "This is a legally binding contract. If not understood, seek legal advice." I bring that up to both my buyers and sellers when we're going over the purchase agreement. Generally, you can explain the process, but if they don't have a full understanding, make sure that they know they can seek legal advice. The first blank on the purchase agreement is for your brokerage, and of course that's going to be Better Homes and Gardens Real Estate. The next blank is the date, and that's the date that you're writing the purchase agreement. Number 1 is the property address, and that can be found in the MLS or wherever you went to. The legal description, I actually look up the legal description in the county assessor. I just copy and paste it and put it right into my contract. That way I know it's been recorded correctly and there's no room for error. And then of course you have to put the county. So if it's Douglas County, Sarpy, whatever. Now number 3, let me teach you this lesson. So number 3 is the personal property to be included as part of the contract. So that's your range oven, all of those things. Now, while you're looking at homes with your buyers, if your buyers are expressing an interest in a home, I would go ahead and write notes or take pictures of the personal property. And that would be like shelving in the garage or a workbench, that kind of thing. Anything that they are going to want to ask for. Say, for instance, an expensive wine refrigerator that you might forget and then might have to pay for later. So to avoid that, try to record everything. Now, number 4, conveyance. So the seller has to provide a clean title, and it only conveys as a warranty deed. So we do warranty deed only, and it needs to be free and clear of liens with no exceptions. Number 6 is the consideration. That is the offer of the purchase price amount. It's written in the letter form and then numerical form. And then the following terms is the earnest deposit. And then you have to mark where that goes. And generally speaking, it goes to the escrow agent. I have never done anything different than the escrow agent. Now, there's still some more terms in that paragraph. In paragraph 6, the things that they talk about is where the earnest deposit would go in different circumstances. So if you're providing an earnest deposit with the contract that day and the contract is not accepted, the earnest deposit is then returned to the purchaser. Now, if there are incurable defects in the title, then the earnest deposit still goes back to that purchaser. Now, if the purchaser wrongfully refuses or fails to consummate the purchase, then the seller can retain the earnest deposit. That being said, if the return of the earnest deposit is in dispute, the escrow agent will not release the funds or the earnest deposit without signatures by all of the parties or a court order or arbitration ruling. And that is actually stated in number 6. Now, number 7 talks about cash financing. And all you do to fill in that blank, it's your purchase price minus the earnest deposit. So that's the balance that you'd put in there. Now, number 8 is conditional upon financing. So that is if your purchaser will be acquiring a loan to purchase the property. It's the most common. That balance is, again, the same thing. It's the purchase price minus the earnest deposit. Now, there's the next blank is the amount that they're getting in the loan for. So You would fill that in the numerical value, and then you would note what kind of loan they are going to get. And then the next blank is your estimation of the principal and the interest payment only. That doesn't include the taxes and insurance. And then the interest rate. Now, on both of those, my mentor suggested to me to pad those or to round them up a bit in case interest rates change. That would change the principal and the interest, and obviously the interest rate. So we don't necessarily know what that rate's going to lock in at. So maybe just a little bit so that you still have a legal and binding contract. And then, of course, the final blank on that page, you fill in the number of years on the loan. So obviously the most common is 30, but there's 15, 20-year loans, and there's ARMs. Let's see. And then loan origination and service fee is to be paid by the purchaser. Now, 8.2 is still part of 8. That talks about that the purchaser agrees to make application for a loan within 5 business days. And then it talks about the company that they're applying for the mortgage with, their loan officer, and the phone number. There's still more to that. So if the financing is not approved within, and then you fill in the blank from the date of acceptance, the offer is null and void. The deposit is still paid back to the purchaser, so that earnest deposit still goes back to the purchaser in that situation. Now, there's more to it in that if the purchaser gets denied a loan and the seller and the purchaser agree, the purchaser can try to attain a loan from somewhere else, but that has to be agreed upon in writing. If we go back to that first part, if the purchaser is denied a loan, the purchaser authorizes and instructs the lender to notify the purchaser, the seller, and any real estate agents involved in the transaction in written notice. Now, notwithstanding the foregoing, if the approval or denial is still not issued within 10 days of the approximate closing date, the agreement can be voided by the seller with written notice to the purchaser. Again, the earnest deposit would still go back to the purchaser. Number 9 is seller financing or loan assumption. I have yet to see that, but there are check boxes in case you come across that. Number 10, for 10A, that is if your purchaser has a home to sell that is not under contract. And so you would put the address of the home, and then if you want to attach an addendum, there's a checkbox for that as well. 10B is if your purchaser has a home that is already under contract, you would write the address and the approximate closing date in those blanks. Now, C is other provisions. That's for any other provisions that you want to write into the contract. Some of the things that are commonplace in there is the earnest deposit is to be tendered within 48 hours of an accepted contract, or that see multiple offer addendum as part of the contract. There's different things that can be written in here. A house is being purchased as is. Void option B from the home inspection. Probably more professionally written than that. Now, 11 is regarding the taxes. Okay, so the taxes in Douglas County and Sarpy County are paid in arrears. It's the only 2 counties in the state of Nebraska and probably in the United States that are paid in arrears. But when we sell a property, they are treated as though they are current. So the purchaser is buying the property and paying prorated taxes as though they are current. Now, in any other county, they're current and the purchaser is paying the taxes as though they are current, which they are. Okay. So number 12, this is for rental properties, leasing properties, so investment properties. And the first part of this says that all leases and rents should be current and not in default at closing. Now, Any of the deposits or the leases should be assigned to the purchaser at no cost. And then all the rents would be prorated at the date of closing. So those fees would be, or the rents would be split per closing date. Now, copies of all of those leases have to be shown or provided to the purchaser within 10 days of the accepted contract. And if there's a lease or a contract that is unacceptable to the purchaser, the purchaser can terminate the agreement and then still get their earnest deposit back. And then number 13, it's sanitary and improvement district. And there's a couple of different things that are important to note in here. First and foremost, you need to put the SID number in here. The purchaser, this is more so for the purchaser to notice that they are in an SID. And there's some important points of that SID. First and foremost, that their properties located in it, that that sanitary and improvement district is located outside of the corporate limits of any municipality, that they're not eligible to vote for municipal elections. And then finally, there are some services that they'll have limited access to. Quite oftentimes it's trash, so they might have to pay for their trash. And there's a couple of different companies in the metro area for that. But there are other things that they're limited to, so don't just use that as the only thing. And then they're limited until it's annexed by the city. And then number 14, which is on the page, the top of page 3, is the conveyance of title. So essentially, we talk about the closing date here, but there's a little bit more to it than that. The seller has to furnish a current title insurance commitment. If defects are found, the seller has to cure it within reasonable time. If it's not cured within 14 days of the approximate closing date, it can be voided by either party. And then obviously you're going to put in your closing date, and then if possession is going to be at closing, and then you put a different time. And then underneath that portion, let's see, it talks about that the purchaser, if for some reason there are delays, that the purchaser and the seller hold harmless all parties. So that's the lenders, realtors, the escrow closing agent, and the title company. And then any claims related to any delay in the occurrence of the closing, that's also, everyone would be held harmless to that. Now, according to the Real Estate Settlement Procedures Act and its accompanying regulations, the purchaser, if they pay any part of the title insurance policy, they get to choose their title company. The seller cannot make it a condition of the purchase. We oftentimes see in the agent notes in the MLS that the agent will write that the seller has requested that they use a certain title company. The purchaser can always choose. So just so you know, that is the situation. So you have to rate the title company that the purchaser is going to choose and check that box. Now after that, the purchaser needs to choose if they want it expanded Alta homeowners policy of title, or if they want basic. There is a difference. There is a difference of the coverages, and then there's a difference of cost. I would recommend to you that you look at different title companies' websites, or some people provide brochures that show the differences to help make your clients aware of the differences of the two things. I would say most often we see expanded being used. The cost of any title insurance policies and endorsements are equally divided between the purchaser and the seller. All right, we're on number 15, escrow closing. The both parties acknowledge the closing of the sale is by an escrow agent, and the earnest deposit is sent to that agent or to the company. Now, after the earnest deposit's transferred, the broker is no longer responsible for the funds. The escrow agent is. And then escrow closing costs are equally shared, except for in a VA loan. In a VA loan situation, the seller has to pay those. And then an escrow agent shall be named. If the escrow agent is not selected, it's the title insurance agent that becomes the escrow agent. And at closing, the purchaser is required to either wire their funds or have a cashier's check for all the rest of the closing costs, which of course we know. All right, number 16, utilities. So the purchaser has to sign up for utilities before the date of closing, but they sign up for closing date. So normally we see about a week and a half after. When I recommend to my clients to do it is right after we get the appraisal returned. Now on number 17, it talks about homeowners associations and protective covenants. First and foremost, it just recognizes that the property may be subject to protective covenants, that the HOA may be able to enforce those covenants, and then that the purchaser can obtain those covenants from the title company, and then that the purchaser has to pay the HOA fees at closing, and those are prorated to the closing date for that year. Now, number 18 is kind of exciting if you're going over this with your purchaser, because it says that the seller has to pay the state documentary tax. So that's always something nice to tell your purchaser. Now, number 19 is the affiliated business arrangements. And that is just acknowledging to the purchaser and the seller that realtors or real estate agents may receive financial remuneration from the sale of title insurance or other insurances or services. You will have to provide a document of the affiliated business arrangement disclosure about green title, because there is financial remuneration with green title. On number 20, release of information. The purchaser and the seller authorize the release by the broker and the agents of information. This is information like the purchase price of the home, any seller paid costs, the type of financing. Those get released to the multiple listing services in the Omaha Board of Realtors. And that is just acknowledging that. And then also that the purchaser acknowledges that the listing agent or broker will market the fact of the sale. So you'll put that it's under contract or that the home has been sold. And then number 21, this is decision-making time for the purchaser. Do they want a survey? Well, not just do they want one, but what kind? There's 3 different kinds of surveys. I would recommend that you take a deep dive in the different kinds of surveys and how much they cost. The first one is quite extensive and expensive, and then they can go as minimal as just finding out the pins in the corners of the property, and that costs quite a bit less. But they can also just opt out of the survey unless the lender requires it. And that waiver is at the very bottom of that section. Now, in most situations, even if it's not required, one of the surveys is recommended. Most often, I don't see a survey being done. A lot of times there's already a fence in place and the lines are apparent. Number 22, seller's property condition disclosure. Hopefully you've already sent that to your purchaser and they've already reviewed that with you. But this is just acknowledging that they've received it. And then 23, home warranty. Okay, first and foremost, do your purchaser want a home warranty? Do they want the purchaser to pay for it or the seller to pay for it? Who will the home warranty company be? Is it going to be non-evaluated or evaluated? And how much is that going to cost? Now, they can also waive that. They can reject coverage from home warranty, and that's at the bottom of that section. All right, 24 gets a little complicated. It kind of skips around. So in 24, first and foremost, it's important that the purchaser knows their options as far as inspections. The most common inspection we see is a whole home inspection. Now, if it's somewhere that has a septic system or a well, you'll want to provide those or suggest those inspections as well. And oftentimes the lender will require that. The other one that we most commonly see is a radon test. Let's go ahead and talk about the whole home inspection first. The whole home inspection, it talks about the different things that they look at. So I would recommend that you read through this section thoroughly. Well, the entire purchase agreement thoroughly, but you can find out the different things that a whole home inspection covers, which is basically foundation to rooftop. They cover all those. And what happens often is instead of just jumping to a mold inspection, during the whole home inspection, the inspector might recommend having a mold inspection done because the inspector might have seen signs of mold. And that's usually how those other inspections are done. Now, in this agreement, it does say that the inspections need to be done within 7 business days. You can lengthen that or put in a different time frame. There is a blank for that. Let me make sure I'm covering everything on this. 7 business days. And then it also says that the seller has to let the inspector do it within a reasonable time frame or within that time frame. Now, this is where we start skipping around. We're going to go right to what happens after a radon test. Well, if the radon test comes back and it's over 4 picocuries per liter of air, so if it's 4.1, the seller has to mitigate. We know the average cost of mitigation runs between, well, let's just say 800 or more. So the seller has to mitigate that, and then they have to either provide a test reading lower than 4.0 picocuries or a guarantee from that mitigation company. One of those two things has to be provided. And then they also have to provide a transfer of warranty from the mitigation company to the purchaser, and then and a paid receipt, obviously, so that they know that there won't be a lien put on that. And then the very last part of that states that the purchaser is agreeing to that mitigated condition. Now, we're going to switch back gears to about the home inspection. So on the top of page 5, they talk about the purchaser's response to a whole home inspection. The purchaser has 3 days after the whole home inspection to respond, 3 business days to respond. Now, there's 3 different responses, and these all will be covered on the inspection resolution addendum. Option A, wow, the house is great. Don't change a thing. We'll take it the way that it is. B, we really love your house and we still want to buy it, but we'd like you to make some repairs. Generally, those repairs fall in the category of health, safety, or structural. So a lot of times we'll see plumbing or electrical, those kinds of things put in there. Now, and then there's option C. There's a little bit more wrong that the home is unsatisfactory, or the home inspection report has come back and it's unsatisfactory to the purchaser, that they would like to terminate the agreement, and then they want the earnest deposit back. Now, all of those things can be covered on the inspection resolution, and you have to provide that within 3 business days. Now, once that's been provided, the seller then has 3 business days to respond. If that has not been provided to the seller within 3 business days, the purchaser is accepting the home in as-is condition. Now, if the seller gets 3 days and they don't respond, it is also that the seller is saying the purchaser will have to buy the home in as-is condition. They can respond in any way that they see fit, but if they don't respond, it's saying that the purchaser will have to buy the home in as-is condition. Now, it's back on the purchaser. the purchaser still has another 3 business days to decide if that's acceptable. Maybe B, they chose option B and the seller doesn't want to make any repairs. So then the purchaser has to decide if they still want to purchase the home. And then they have to provide that in writing, right? Now, after the home inspection, the purchaser still has the ability to get their earnest deposit back on any of those categories. And let's see, let me make sure that we covered all of 24. Yes. Okay. So 25. What 25 is talking about, it says this offer is based on the purchaser's personal inspection or investigation of the property and not upon the representations or warranties of the condition by the seller. So the purchaser is buying the home by what they see and not by what they're reading. Now, if they want to buy a house that is only 2,200 square feet, and that is what the seller has written, but they have questions about that square feet, the purchaser should conduct their own independent investigation with regard to that. Now, going to number 26, the condition of the property. This is a little bit more onto the seller in the beginning. The condition of the property, the seller represents that there's no material or latent defects in the property. There's no environmental hazards or liabilities, or there's no enforcement actions pending or threatened, except for anything that's been disclosed in writing ahead of time. Now, the seller agrees to maintain all the equipment mentioned and maintain it into operable condition until the delivery of the possession. And it goes over many of those things. That's like the sprinkler system, the HVAC, those kinds of things. And then the final part of number 26 is talking about that the seller will allow the purchaser a final walkthrough of the property. And there's a blank for like the number of days that you want to allow that to happen. I put 3. I've seen 1 or 2 also in there. Now we're talking about bugs. 27 is wood infestation. And what this covers is any wood destroying insect inspection. So the purchaser is to pay, unless of course it's a VA loan, then in that case the seller has to pay for the cost of a wood destroying insect inspection. So number 1 covers that blank, covers the company that you would choose for that. And that inspection has to happen within 10 days of the contract. If termites are found, the seller has to mitigate and make any necessary repairs. That report, if the report that's done has to be distributed within 5 business days of the inspection. And then say if there is damage, if there's over 2%, or you can write in, and sometimes I see people write in 1%, either party can cancel the agreement. It has to be canceled with written notice, and it must be within 15 days prior to the closing date. And then in this situation, the purchaser still gets their earnest deposit back. All right, we are on the next page on 28. Insurance. The seller has to hold homeowner's insurance on the property until closing or possession, whichever date is earlier. Now, there's more to it than that. If the property is materially damaged within that pending contract, the seller has to notify the purchaser in writing. And then there's a few options. The purchaser can rescind their offer. They can take the property subject to the damage with the seller paying any of the insurance proceeds and then the deductible for the replacement or the price discounted at the cost of the restoration. And then the final portion of that is just saying that the purchaser has to pay for homeowners insurance at closing. Phew, we're getting there. Number 29. Oh, this one's an easy one at least. The seller has to provide smoke detectors and carbon monoxide alarms in accordance to the law. So that's a nice, simple, easy one. Number 30, it talks about compensation of the selling broker. This is also the broker admin fee or admin compensation, the BAC fee. And what this talks about is that the purchaser shall pay the BAC fee at closing unless the loan doesn't allow it. There are loans that don't allow a BAC fee. The seller and the purchaser agree that the broker can collect from both. So if it's a dual transaction, you can collect from both parties. There we go. And then let's see. 31, lead-based paint addendum. If the property was built before 1978, the seller and the purchaser both have to fill out the lead-based paint disclosure. And if you're on the purchaser side of the arrangement, you have to make sure that your purchaser also has the lead-based paint pamphlet. I actually just have my people sign it, and I keep it in dot loop, so I have record that they have received it. Number 32, it's unlawful to discriminate, and there is a long list. But basically, it's any part of the transaction or any leasing, that kind of thing. It's race, color, religion, national origin, ethnic origin, familial status, sex, handicap, disability, sexual orientation, and in the city of Omaha, it's age if the individual is 40 or older. There are communities that are 55 and older, and so they can not allow younger people. Number 33, any modifications done to this contract have to be done in writing and all parties have to sign. So nobody slips in any changes, right? Number 34, electronic transaction authorization. Basically, there's a couple of different parts to number 34. Essentially, it is acknowledging that all electronic signatures, initials, check boxes, marks, those are all legal. And then if a document is sent back and forth, it's still recognized as one single document. And then 2, if there are manual signatures, if they're scanned, faxed, whatever, it's still all recognized as the original document, and that either agent will have to submit the original signatures if it's requested. All right. Number 35. It's kind of a long one too. So maybe sit back and relax a little bit. The first part, well, we're going to skip over the very first part. There's an empty box. If that box is checked, we're not going to skip over it. If that box is checked, the purchaser is waiving they're waiving arbitration and mediation, and they have to initial right beside that. Just make sure we're all on the same page. So if this is checked, they're waiving it. 35A, it just explains what a dispute is. And then 35B talks about mediation. In arbitration and mediation, the mediation is a non-binding mediation. Basically, it's a little bit less expensive way to try to get people together to settle a dispute. And in this document, it describes that it has to be given in 15 days of written notice, that it has to be done within 365 days of knowledge. So it spells out pretty much who, when, and then who's going to be ruling over that. And that is the American Arbitration Association. Now, if the parties still cannot settle that dispute from mediation, it's moved to arbitration. Now, arbitration is recognized as binding. So any dispute not resolved by mediation moves to that binding arbitration. This paragraph further explains who provides the mediation at the time frame that it must be filed, It also talks about that the prevailing party shall be entitled to the cost and the fees of arbitration, and potentially they could be awarded the attorney's fees. It's up to the arbitrator on that. It's as they see. And then E, oh, didn't turn my page. Now, on E, it talks about different exclusions, and those exclusions to arbitration and mediation. The exclusions are for a foreclosure action, the filing or enforcement of a construction or some similar lien, and then an action filed and held in small claims court. So your purchaser, if there's a dispute and they can't settle it, they can go to small claims court. And then F talks about, by signing the purchase agreement, all the parties recognize that arbitration is final and binding, and they're giving up their rights to litigate claims and to enter the disputes into court. All right, whew, got through that one. Number 36, that's the offer expiration, that you are telling them, we want you to decide on our offer before this time. And so you put a date and a time. It depends on the circumstances on how you do that. And then number 37 is a list of the attachments, the addendums, and the disclosures that are part of this contract. So if you have added something like a multiple offer addendum or escalation clause, you'll want to write that in and check it so it's seen as part of the agreement. Now, on the top of page 8 is the purchaser's signature for the agreement. It's also their information, their address and phone number. The next part below that is the name for the deeds. Now, it's been recommended by our title company that you use the names that are as they are shown on their driver's license. You'll also want to talk to your purchasers if there's more than one person, how they want to take that title. Most often we see that married couples do joint tenants with rights of survivorship, but you can't make that assumption. There might be extenuating circumstances if there's adult children from a prior marriage, something like that. So you'll always have to ask and discuss that with your clients. The next area is the buyer's agent information. You should know all of that. And if not, you can look it up in the MLS. If you don't know your office MLS, it will be in the MLS. The final part on page 8 is the receipt of the earnest deposit. More often than not, the earnest deposit does not go with the purchase agreement. It's tendered later. And so then you can say, mark that checkbox and say that it would be delivered later. And then, of course, if that's the case, you wouldn't sign the receipt because you haven't received it. We're on page 9 of 10. We're almost there. All right. The top of page 9 is the seller's acceptance. Now, if there is any sort of a counter, that's even a counter to the expiration time, say they needed more time, you would write that counter in the area and have your seller sign it. Now, if you write any sort of counter in there, then the purchasers will have to sign an acceptance of the counter, and that's below. But in between that is the seller agent information. If you are filling out the purchase agreement, I'd recommend just to look up the information for the seller's agent in the MLS. It's a nice courtesy. So then the purchaser, if the purchaser decides that they also want to counter, there is room for another counter and then a final signature from the seller of the acceptance of that counter. That's so much to say. If there's continued counters, you can do that and make it a part of this. You can do it in a general addendum and write it as part of this contract. Now, in the middle of page 10 is the real estate certification. That is saying the sellers, the purchasers, and the agents involved in the transaction, all certified to the terms of the purchase agreement, are true to the best of their knowledge and belief. So everyone signs that. Now, the very last thing is the purchaser's receipt. Your purchasers are not going to sign this until everything is completely decided. all of the counters have been, all of the counters are done, and the signatures are on there from the sellers. And the reason is once the purchasers have signed the receipt, it's considered, and then it gets mailed to the listing agent, it's considered a fully executed contract. And that is the entire purchase agreement.